Okay, it is Monday, October the 14th, 2019, also sometimes referred to as the observation of Columbus Day, and welcome to week three. Week three, guys, be aware of the fact that when I say week three, that I am talking about the course being halfway over. And before you know it, we'll be at week 6. So I want to make this announcement that starting with the end of week 4, any assignments from weeks 1 to 3 that have not been previously submitted will not, I repeat, will not be accepted. And so it's important that those of you who are behind to catch up. You will still end up losing points unless there's extenuating circumstances that I determine, then you won't. However, there is no reason this particular time that you cannot get your assignments from week 1, week 2, and week 3 in. I have graded this week 1 already, and you will discover that I will be starting on your week 2 assignments and so by Friday I will have completed. So be aware of that and keep that in mind. So now let's go ahead and get started. I want to start out by sharing my screen. Okay. And you see here some information that you're very familiar with already. So I'm going to start with the module, which the rubric, written assignment, freedom of the press, and the right to a fair trial. And we're going to talk about that a little bit tonight. So for your assignment, remember it's going to be APA, which means citations in the body, references at the end, margin 1 inch on each side, also double spaced, citations in the body throughout the and references at the end on a separate page, along with a cover sheet, Romans 12 rather, and then cover sheet. Make sure all those requirements. Now, also you should have a properly formatted cover page, and you all know how to do that. Use it as well. So in this assignment, you're going to get 30 points if you describe that you believe the press has what effect that it has on jury trials and on a fair trial. Explain your position using the First Amendment as your support, and then satisfy the requirements of the right number of pages, which you're going to find out when we look at the module. So that's the written assignment. Then we're moving on down. Then there's a course project. The course project is related to the Fourth Amendment, as you were introduced last week when you picked your topic. So the area that you're going to do, you're going to provide case briefs with proper citations, which you're aware of how to do that in your area. Write a synopsis on at least 3 secondary sources. Secondary sources, which are like articles, magazines, and things of that nature. And then you're going to, of course, have the requirements satisfied here of APA that I previously mentioned to you as well, and the page requirements. So we're going to cover that in a minute. So moving down, you'll see that this is week 3's lecture, and then we have 3 more left after this. Down here at the bottom, there are the archives or the recordings that I previously emailed to you, but you can also find them here. After tonight, it'll say week 3 lecture, and then it'll have your corresponding link for YouTube to be able to view the video. All right, so let's go over here and let's take a look at our week 3 announcement. So our week 3 announcement involves the topic of protecting basic freedoms, and you're going to have to read chapters 5 and 6 of the text. I also previously sent you some information that could help you with looking at the material or researching it, as well as the PowerPoints that actually is an outline of the chapters 5 and 6 as well to help you. Then we're going to discuss the First Amendment and gun control, and we'll be talking about both of those in just a few minutes. There is a discussion assignment this week that gun control and the Second Amendment is involved with that, as you should be aware of, and initial post is due tomorrow night on that topic. Now, again, not many of you have had this problem. Make sure you have detailed posts. Make sure you have provided information that I know that you have given some thought, and then you don't just provide a very brief answer to the questions. And so your initial post is due Tuesday, and then of course your reply post is due this Saturday at 11:59 p.m. Central Standard Time. And then again, I encourage you again to reply to more than one post. Several of you have done that, and that's good. You don't get extra points, but what it does is it allows you to connect with your classmates, and it also provides an opportunity for you to make the discussion more interesting. And so there's a lot of debate about gun control. I already posted a post in there where I explain my position and why, and I'll be probably talking about that again tonight during the lecture. Finally, complete the written assignment, freedom of press and the right to a fair trial, which I just went over the rubric with you, and then the Fourth Amendment project, relevant case law. And then there is the midterm exam, which is timed. Now, the midterm exam includes materials from weeks 1, weeks 2, and weeks 3. Okay, so you'll have those to do. And then after that, if you can complete the mid-quarter student survey, I would appreciate it. Then you know about my motto, you know what that is all about. So let's quickly take a look at the course calendar, which I remind students to download, or if you can't, just be aware that it's in here, and it gives every thing that we have here. So let's take out the 115. That's introduction to correction. So there we go. So this is your this is where we are now, the 14th, and it involves your reading assignment, which I just gave you a few minutes ago, and tell you where to find it. And then your initial post on gun control, and then your reply posts. Your assignments that are due Sunday the 20th, written assignment, your Fourth Amendment course project, your time midterm exam, and then of course your key phrase that will be given. Okay, and then the next time we come back together will be the 21st, which will be the start of week 4. And remember what I said, by the time we get to the end of week 4, which is the 27th actually, when assignments, then you had to have given me weeks 1, weeks 2, and weeks 3. If you don't have them in by then, after that I will not be, because what students do is they get to week 5 and then they want to go back and do weeks 1, 2, and 3, and it's not going to happen. It's not going to happen. So I've given you a forewarning on that issue. Okay, so let's shut down the course calendar here, these tools here. Okay, and now let's go to the module itself and discuss the topics. So first again, let me reiterate the assignments again. The Fourth Amendment Project, relevant case law. Now, I've already given you the rubric. So this is the course project. Remember, it is the Fourth Amendment and the chosen area that you decide to focus in with week 2. Stay with that one. So now your next step is going to be to conduct in-depth research concerning the Fourth Amendment and the relevant area that you're in, and find relevant case law and secondary sources. Again, I told you secondary sources are articles, journals that discuss your amendment or case. All right, so those are secondary sources. All right, so there's plenty of articles and plenty of journals out on the Fourth Amendment and the areas that you chose, and that you want to use this project. Well, so you're going to submit in the assignment case briefs, including proper case citations that you've chosen for your final project, which is what you chose week 2, and then a synopsis or about a paragraph of at least 3 of your secondary, on at least 3 of your secondary sources. All right, and then your paper should be proofread for correct spelling, grammar, and punctuation, and so forth. Now, this does not tell you how many pages, but here's what I'm going to recommend to you, that it should be at least 1 page, 1 full page, not a short thing, at least 1 full page, because your briefs are going to be included, and possibly even more, all right, as well. And make sure you have citations and references. Now remember, you're going to have citations for your secondary resources that you're going to provide in there, and then you're going to have references at the end. Then your written assignment, freedom of the press, is a 1 to 2 page paper, okay, with the First Amendment to support your answers. All right, so it says every person tried in a court of law has a right to a fair trial under the Sixth Amendment, and a trial must be public, except when it's a juvenile. Now, and so under the First Amendment, the press enjoys the freedom to report on these, and so you're going to write about whether you believe that the press can have a potential effect on the jury pool, which is selected to determine from usually registered voters, and does that adversely affect the defendant's right of a fair trial that they're guaranteed to or have a right to under the Sixth Amendment of the Constitution. You should be citing that information, the Constitution and so forth, and if so, why? And if not, why? Or you can comment about both sides and then come down on whichever side you believe. That's where I usually write my papers, like that. Your paper should be proofread for grammar, spelling, and also the information in the rubric. Make very well sure that you use the rubric. And then the discussion on gun control, I've already talked about that. And then your quiz, which is basically your midterm, consists of 15 multiple choice and true-false questions, and it is timed, and it is set for 15 minutes, which basically gives you 1 minute each. That's your exam, and you're not going to have materials, books, notes, and all that in front of you. That's part of the academic misconduct policy that you'd violate if you did that. If you have technical problems, contact PSC for help. They won't help you with the answers or any of those things, but if you have technical problems. And then your live lecture, you know that already. And then your course survey. So those are your assignments for week 3 that I've gone over and explained what you need to do. All right. Of course, if you have any issues, you know how to reach me and you know what to do. Very important that you always let me know which that you're in, because I have classes that I'm currently teaching at the present time. Okay, so we're going to deal with the First Amendment and free speech, and then we're going to deal with guns and the Second Amendment tonight. Reminding you, too, that you need to contact and schedule your interview for Module 4 for your project that you're doing. All right, remember that we went over that during week 1. So here you're going to talk about amendment and gun control in a minute, and then your Fourth Amendment project. We've already discussed that. We've discussed the written assignment, freedom of the press, and the right to a fair trial. We've discussed the gun control issue, and then we also covered your midterm student survey and that. All right. So now let's talk about the First Amendment first. We're gonna talk about that, and then we're gonna conclude by talking about guns and the Second Amendment. So anyway, the First Amendment is quoted right here at the top of the page here, that basically says that the First Amendment protects religion, free speech, and of the press, and the right of people to peaceably assemble or to protest, and to petition the government for problems that they have as well. So when you look at the First Amendment, which you can click on it, but you're probably not going to find it because there it is right there. Sometimes they don't put it in there. Okay, it's transferring you to Encyclopedia Britannica, which in this case, there we go. And it talks about the First Amendment. And then here's a nice article, a nice article in here about it. So you can take a look at that on your own, okay, regarding the First Amendment. But be aware that the First Amendment comes into play in terms of criminal law when you start to deal with protests primarily. You're not really so much dealing with the other issues there, but when you start to deal with protests. And First Amendment is the foundation that gives us the freedoms that other countries don't give, that allow us to discuss openly and freely various issues, and to take positions that are opposite from the government without retaliation, as long as it's not like threats or things of that nature. So it says that here, it says it seems to be more about the freedoms, that's the First Amendment, than crime and criminal procedure. But again, the First Amendment deals with, as I said, the peaceful protest. It also deals with obscenity and materials like obscene materials. Now, there are famous cases that are involved with obscenity, and I'm not going to talk about those. But anyway, the thing I want to jump right into is, well, I'll just briefly say that in the Miller case, obscenity is defined in 1973 in a landmark decision that determines what is obscene, and it's based on a 3-part test. And so basically it allows things that you might not like, but it also says pretty much that if there's some artistic, political, or scientific value to the material, even if it doesn't please you, it's allowed under Miller. And so pornography itself is allowed to be expressed in the United States, but the test described above, the Miller test, is applied to determine whether it's protected or whether it's obscene on it. And so the issue about child pornography is different. And so child pornography, on the other hand, is protected stronger because of minors involved. Exploiting a minor can not you cannot use the First Amendment as a protection when you start to use what is determined to be child pornography. Okay, so and the reason for that is because children are, they need to be protected. It says that due to the fact that children are a very special class, the court said that they deserve even more protection than what the obscenity test provides, and that's what I was just saying a few minutes ago. So in a case called New York versus Ferber, the court said that states have more regulation that they can impose when it comes to dealing with child pornography than what's in the Miller test that we previously have discussed. Okay, and so the key thing is that the court wants to protect youth and welfare of our children, and that's pretty much where it is. All right, now, so let's talk about the First Amendment and the freedom of press, which is not covered here, but the freedom of the press to report on cases and to provide details, to provide information during the course of investigations, because the public has a right to know. And the public has a right to know for a number of reasons. One of the primary reasons is to be aware of what's happening in their general community, so they can be aware of what's happening around them, such as crime and things of that nature. And so the other reason that the freedom of the press is there is because of the fact that the Constitution gives them the ability, the media, the ability to provide facts, or as much as possible, or information, and that is covered under the First Amendment when it says not abridging the freedom of speech or of the press. There are people who say, well, the press shouldn't be allowed to report on cases. And one of the arguments that is made is that the freedom of the press clashes with the freedom of or the right of individuals under the Sixth Amendment to a fair trial. Well, there is a balance that takes place because, as you may or may not know, judges have been known to issue what we call gag orders. And when gag orders are issued, this is an order where the court actually basically puts a gag, so to speak, not physically, over the mouth of the lawyers, the media, the defendants, the prosecution, everybody involved, the law enforcement people, everybody, not to talk about the case. And the reason for that is an attempt to try to protect the rights that individuals have to a fair trial. When it comes to pretrial information that is provided, oftentimes it is argued that pretrial information seems to create a prejudicial effect on potential jurors, where jurors are going to be exposed to information and that they are not going to be fair and impartial when they come, and that it's harder to find. And there are lawyers who have filed motions, including yours truly, to seek to change the venue or the area where a case takes place because of pretrial publicity, and that the individual couldn't possibly get a fair trial as guaranteed by the Sixth Amendment because of the press and how they cover the details. Now, there is a built-in process in most investigations that the law enforcement people, if you listen to them very carefully, generally have what we call a public information officer, or PIO, or PIO, public information officer. And what that person does is that they have the responsibility of making comments or responding to the media, and they're trained, and usually most of those are former media people and they then will formulate responses to questions that the media has concerning an investigation as it takes place. And then you will often hear the statement given is that they can't comment because it might interfere with the investigation itself. Again, speaks to the point of giving the law enforcement people the ability to be able to determine that they are resolving the issues or solving the crime or getting closer to solving the crime without tipping off someone that they're on their something along those lines. The other part is that individuals who read newspapers, hear accounts before a trial of a high-profile case, is then selected from a panel of registered voters in many jurisdictions, and they are then brought into they're brought in by what we call a summons to serve jury duty, and then they will appear, and they will be selected by panels, and they will be taken into the courtroom, and the lawyers themselves will have a card that has been previously filled out by the potential juror, telling some stuff about themselves, and there are questions that lawyers can put before those jurors based upon that information and ask them, about their position concerning the case without getting into all of the facts at it's called voir dire, or to bring out the truth. And so during that period, individuals, then one of the questions that's often asked is knowing what have you been asked, have you read about this, have you heard about this? And the answer generally is yes, if it's a high profile matter. And then that individual then could be asked, know what you've read and apply. Will that prevent you from being fair and impartial, and then having your decision made based upon the facts that are rather the evidence that's in the courtroom? And if the answer is yes, they say yes, they're okay. They say no, then they might have an issue and be excused by the judge. Then the lawyers have what we call peremptory challenges. Peremptory challenges are given to each side to excuse jurors, even if if they have a feeling that that juror would not be beneficial to their case, or would not be telling the truth about the answers they might give, whether they could be fair or impartial. The only thing that you cannot do with that, and should not do, is if your pattern of using your peremptory challenges appears to excuse people in a pattern that makes it clear that you're eliminating a certain race, a certain sex, a certain national origin, then you won't be able to do that. There's a famous case, it escapes me the name of it, I think it's Baston, but at any rate, you can't do that. And so the other thing is that once individuals are impaneled and selected as jurors, there is often, and especially in high-profile cases, this is when it really happens, is that the jurors are then sequestered, which means they are locked up, not in jail or anything like that, but they are under guard of the sheriff's office, and they are guarded about what they read, their TV time and things that they watch, who they might be able to communicate with and talk to, and they're not even supposed to talk among themselves about the case until deliberation time. But the point of the matter is that is a way for the judge to not allow the individuals to know what's going on when the media, because there's media coverage when the trial starts, and individuals who are jurors should not be, should I say, persuaded some news media coverage, and they should keep their focus on the evidence that comes from, as the judge says, from the stand. Even the opening and closing statements in cases is not evidence, it's just summation. But the evidence is what comes from the witnesses on the stand and the exhibits that are produced as a result of the witnesses on the stand. And you take all of that together, and the jury then determines how they feel about a case. And then before a case is turned over to the jury, after all the process is gone for the opening, the rebuttal, the testimony, the evidence, and all of that, then the judge gives what we call jury instructions to the jurors. And the jurors are then given, in many jurisdictions, like in Illinois, we have what we call IPI, Illinois Pattern of Instructions. So what it is that there are synopses of the elements of the law that tell what needs to be proven in order to reach a finding of guilty by a person. You already know the standard is a reason beyond a reasonable doubt, but I'm talking about there are elements that must be proven by beyond a reasonable doubt as whether or not that person is guilty of the offense. It's not about whether you like that person, even though we're dealing with human beings, but that's pretty much the way it works. So after they've given this information, then jurors then are allowed to go off, and they will take them and put them in a room, and they will allow them to deliberate. One of the first things that generally happens during deliberation, as I've been advised, is that a foreperson is selected. That's the person who basically conducts with the jurors themselves. And we don't know who that foreperson is generally until after the verdict. And so the point of the matter is that they're given a chance to discuss among themselves at this time what their positions are, and then they'll take a vote. And in criminal law, it must be a unanimous vote in order to find a person guilty. If one juror decides as a not guilty, then we have what we call a hung jury, and sometimes the judges will order them to redeliberate to discuss whether or not they can change their position. And I can tell you that I have my oldest daughter once served jury duty in a criminal case, and it was interesting that she even got selected with what you know about my experiences. And so basically her grandfather, and then there were some other experiences, grandfather and grandmother, and then now with her adopted grandmother, who was kidnapped and shot. I'm going to talk about that in a few minutes, and I did mention that in the discussion forum. But and so anyway, with her having all of that information, and then recognizing the fact that I was a defense attorney, I was a prosecutor, I was a police officer, I was a paralegal, and they all this was given to them, they still allowed her to get on the jury. Well, what happened is that the jury had 11 that voted guilty and 1 that did not, and it was her. And she refused to change her position. So even after the judge ordered them to redeliberate, she still remained in her position, and therefore we have what we call a hung jury. In a hung jury case, what happens is the prosecution has the option to just retry the person, or either to retry the person with a separate trier of fact, whether it's the judge or either the jury. Now, this is not a violation of the double jeopardy clause. Some people think that, because no, what it amounts to is that that person, the prosecutor, a choice. So once they go over that point, then it goes from there. And incidentally, She hung the jury in the first time, and a second jury tried the same young man and found him not guilty. And as it turned out, that was the right decision. But it was right. So I'm saying all this to say is that, and this wasn't a high-profile case. Been in some high-profile cases. The O.J. Simpson case was a high-profile case. There's been many high-profile cases that familiar with the Trayvon Martin case, and it goes on and on and on. But the point of the matter is that the trier of fact, in this case the jury, is away as much as possible from the press's reporting, and they are even kept out of the way. And even in most instances, the media doesn't even know the name of the jurors, and they'll use, they don't use that information. So that's how the First Amendment operates. And I think I've given you some ideas about how the whole issue about the freedom of press operates in terms of the Sixth Amendment and the individual right to a fair trial. So now, and let's go to the Second Amendment. Second Amendment, which is says a well-regulated militia being necessary to the security of a free state, the right of the people to bear and keep arms shall not be. Now, if you clicked on it, will take you to, again, another article and some information that you will be able to read about the Second Amendment and the Supreme Court interpretations and some cases. So you'll be able to read about that. Now, let me say this up front, that we are in where shootings are reported almost every day, particularly in urban areas, but it's now in the outlying or rural areas. And so there are individuals who have been shot, such as the high school shootings that you're familiar, like the one in Parkland, and then Arizona U.S. Representative Gabrielle Giffords was shot. The shooting of Trayvon Martin. The issue of gun control is is one of the hot topics, and the whole question that is operating is the right to bear arms and the right to put guns in the hands of the wrong people, such as not just criminals, but we're talking about people with mental and things of that nature. So we have these things called background checks, which are advocated. There's FOID, Fire Owners Identification Cards, in many jurisdictions. Not everybody has. In our state, in Illinois, the FOID card is required if you're going to own a gun, and we have what we call carry concealed, which means you go through a background check, training, and you can have a concealed weapon. And so some states have what we call open carry, which I believe Texas is one of those states. And so some states that I discovered, such as Florida, don't have an FOID card or any type of permit when a person has a concealed weapon. So, you can take a look at your state and see how it compares. Now, let me say this to you up front. I have a degree in political science, and I have looked at the Constitution very carefully, and I have been trained to make sure that when it reads something, you don't just take one section of it, but you apply it all together and to keep it in context. And if you read what the Second Amendment says, and the history of what the Second Amendment was, it says a well-regulated is necessary to a free state. So the closest thing I can think of at this particular time is our armed forces, whether it is the 4-year full military, or either the state military that operates as well. And the point of is that the Second Amendment, in terms of the context, it seems that it was written for the militia. Now, and it says that the right of the people to bear and keep arms shall not be infringed. Now, if you read that together, it makes sense that it was primarily for law enforcement, for security guards, or for and that private citizens. It's argued that the Second Amendment was intended for the well-regulated militia, and that the right to bear and keep arms shall not be infringed. So what the law did not intend to do was to have all these guns out here. And I'm not talking about the illegal guns. Keep in mind, I'm talking about you'll be surprised with how many of these guns that are used in these shootings are obtained through legal processes. And now we've reached the stage where we have automatic weapons and semi-automatic weapons. Now, here's the other part. The handgun was not even thought of at this particular time. What was considered was the musket or the rifle. The automatic weapons certainly weren't contemplated in the time. So what has happened now is the Supreme Court and the various cases that have come up have applied interpretation of what is meant by the right of people to bear arms. And the Second Amendment is the whole argument. Those who are in favor of guns will argue this part. It says the rights of the people to keep and bear arms shall not be infringed. On the other hand, the people who are anti-guns, such as yours truly, the only time I had a gun was the 4 years that I was a police officer, and I've never had a need for a gun. But people argue, oh yeah, we want to keep a gun so we can protect homes and so forth. I can tell you that those same guns have resulted in the death of innocent people, and people have shot their own family members without in a heat of passion, or either they've shot them family, and then not to mention that the youth and children get some of these weapons. And now you see people, they're showing up in schools. Kids are bringing guns. So there's a whole issue here. And so we're at an epidemic stage when it comes to the use of guns as far as killing people. And so it is, and I remember editorial for Channel 7 in Chicago years ago in the 80s. And the editorial, I was a spokesperson selected to stand in because the person who was going to do it was my mother, but she couldn't do it because she was at another station. So I stood in and did the editorial. And one of the comments I made in the editorial was that in the future, now this was in the 80s, people, I said that there will be guns that will get into, and that there will be metal detectors, not just in the courtrooms, but at malls, in schools, and other places. Now, what? You know what the next step? Now we're getting to a stage with the violence that's happened in churches and places of worship where we're heading in that same direction, all because of guns. And so people argue, oh, no, it's not the guns that kill people, it's people who carry guns. Duh, that's just like people who drink alcohol and drive and kill people in an accident. It's not the car. No, it's the operator of the vehicle that causes it. Well, the one who pulls the trigger is the one who causes serious injury or death of individuals. And so we're at an epidemic stage now. Even when dealing with criminals, innocent people are being killed. I know of a case of a young lady that was reported in the news here in Chicago, in a suburb, where she was sitting at her computer in her house doing her work or preparing for a party. And I think she was 12 or 13. She was a very young kid, and a bullet came from somewhere and killed her. So we're having more and more of these type of situations. If you were here with me where I'm doing my lecture, I'm sitting by a window in my a corner of my living room, and a person outside could just fire a weapon, and it could come right through this glass, and while I'm doing this lecture, I could be shot. It's like that now. We're at that stage. It's like a gunfight situation, and it's a scary thing, and so it's problematic. So whenever there is any kind of attempts to try to control guns, because we're dealing with federal and state regulations, and Congress and the various jurisdictions have to pass laws, the lobbying power of RA, the National Rifle Association, has so many politicians that they control because they contribute to their campaigns. So guess what? They basically buy themselves a legislator. So it puts a chilling effect on those legislators to vote for more laws to protect our communities. That's a scary thing, unfortunately, but that's the realities of what we're faced with. So it's the politics that take place. We have the United States Supreme Court that makes decisions. They are on the bench for life, but gets to them, it depends on how they're going to apply that intention of the right of the people to bear and keep arms, not infringed. Are they going to connect it with what the statement was before, a well-regulated militia being necessary to a free state, and the right of people to keep and bear arms shall not be infringed? When you read that again, you'll discover some of the things that I'm talking about that the Supreme Court judge and then law professors and individuals, you'll be able to read some of the really interesting things about gun control, dealing with cases going all the way back to 1986, and dealing with the statutes that have come up after, dealing with some recent cases, you know, where it talks about the District of Columbia versus Heller, a 2008 case, in which the Supreme Court examined the Second Amendment detail, 5-4 majority. Now, what that means is this: when this is 5-4, I'm as a student of political science, will tell you of the 9 justices, that means that one judge can swing it. And you already know the situation that's happening in our present, is that the current president has potentially, if he's reelected again, has the power to swing the court by appointing people that would basically be one that he believed would take his positions, and civil libertarians would be in trouble when it comes to cases. But look at what it says in a 5-4 decision delivered by Justice Scalia, you know, now replaced by Judge Kavanaugh. debate about whether he should have become a Supreme Court. But look, it says the Supreme Court held that self-defense is a central component of this amendment, and that the District of Columbia is dealing with a case involving the District of Columbia, prohibits against rendering any lawful fire in a home operable for the purpose of immediate self-defense to be unconstitutional. Where the Supreme Court previous rulings that the Second Amendment ensures the right of individuals to take part in defending their liberties by taking up arms in an organized militia. Now notice this, I already talked about that. And it says, however, the court was clear to emphasize that an individual's right to an organized militia is not the sole beneficiary of the Amendment. So what that meant is that they took it and said, not only can the militia do it, then what it did, it gave individuals the right to bear arms, so forth. And so you go on and you look at another case, McDonald versus Chicago, which is not the Quan McDonald case, and you read it. But anyway, my point being is that you learn some very interesting points when it comes to dealing with the Second Amendment. And I will say this to you, that the Second Amendment is one of the hot potatoes that we have. Now, I will say this to you, and I said this in my discussion post, that I am a firm believer that guns ought to be controlled, seriously. And one of the reasons is because my mom, and when I say my mom, I'm not talking about my natural parents that you know that were stabbed, but my adopted mom in 1971, and I posted some articles that share about, was the victim of a kidnapping, and she was forced to drive her car some distance into a forest preserve, lay down on the ground, and a guy took a gun out and shot her and her guest twice in the head. They both were shot twice in the head. She survived miraculously, but the other person died. And so as a result of that, even today, she has fragments of the bullets from 71 in her body, and it's 2019, and they can't remove them because she'd become a quadriplegic. The point of the matter is that she became, and I joined her in this, as an activist for gun control. And so what I'm about to say is this, is that many people take the position, whether it's pro-guns or anti-guns, based upon experiences that may happen in their families. There are people who, for example, who lost loved ones in the Parkland shooting and other shootings, Sandy Hook in the government, Fort Hood, where the military post, where my wife had a cousin who was in the military, and he almost lost his life because he was heading in a direction where that happened, but hid behind a tree. And you know, and so now in schools we have active shooter drills. And how come we have them? Because of this gun issue. And so it's something that is a part of our life now. And so what I am saying is that people who lose individuals in them, even if they were pro-guns, they go on the other side and operate on that basis. There's a few who don't, but most do. And if you ever see, I have a good friend that grew up with me. She is a top official in the Chicago Fire Department, and her son was shot and killed trying to protect somebody in high school. And she was among those thousands of people who went to Washington a month or so ago to express to Congress their desire to have guns more regulated. Individuals who lost their lives at Mandalay Bay in Vegas, they're suing, the survivors of the families are suing the hotel at Mandalay Bay for the guy who did the shooting, who took his own life. And you know what happens oftentimes is these individuals will kill people and then they'll take their own lives and those kind of things. But the key thing to remember as I wrap up is that the regulation of state and federal laws for guns is something that can help, but the key thing that's really going to help people is for people to recognize and understand that just don't use the argument, I need a gun to protect my house. Like I said again, it works against you, and I have seen it time and time again. So I hear gun rights people say, well, the criminals have guns. I say, and the point of the matter is that oftentimes the criminals get guns where people who legally had guns and they got access to them. And so as a result of that, there are problems. But again, I get back to what I said earlier, and don't underestimate what I'm about to say, is that the political atmosphere that is created by money, the whole National Rifle Association, and do some research on that, and you'll see. Now, the name of it is National Rifle Association, but their biggest protection is not guns, rifles where people use to hunt. They're any firearm they're promoting and protecting. So anyway, that's all I have to say for tonight, and I hope you learned a lot about the topics of gun control and the First Amendment and the freedom of the press and the right to a fair trial tonight. And so I want to leave you tonight with a key phrase, and that key phrase is something that is dear to me, and that is gun control. And so you give me that and you will get your points. So I'm going to say good night to you guys, and I look forward to seeing you next week at 8:30 p.m. Central Standard Time for another session in constitutional law. So have a good one.